All right, welcome to You Didn't Get the Memo. I'm your host, Gloria Bailey Ray, and as always, we got a fantastic show for you guys again today. And listen, this is so near and dear to my heart. I think with everyone who have gone through the pandemic, and whether you've had a family member or a loved one or someone that you know or somebody who knows somebody who knows somebody, one of the things is planning. And although a lot of people say, I don't like to plan, I'll get around to it. Now more than ever, we need to make sure that we have our house in order. And, my topic today is trust and wills and all this stuff. Oh my. But it's things that we need to do. And we really, really need to be prepared for you guys. And so my guest today has been on the show roughly about 3 years ago, and she is so awesome. She's very thorough. And I want to remind all of you that are tuned in, hey, be sure and place your comments in the comment sections if you have questions, and we'll do our very best to respond to them. But I'm excited to be able to bring to you again another outstanding guest. And I want to welcome to the show Miss Cora Lewis. Miss Cora, thank you so much for being here today. I'm excited that you are here and you're going to just spread and drop some knowledge on some folks because it's knowledge that's really, really important. And you, probably more so than anyone else, can relate to people who've come to you after the fact when things have happened and they really and truly needed to have, all their paperwork in order. And I'm still just amazed at the number of people who fail to plan. I'm amazed at the number of people who think that they know the law. And you know what? Because I'm married, I'm not going to worry about my house going into probate, or, I've lived with this person for 30 years and they told me they leaving everything to me. But nothing is in writing, nothing is written down. And so I thought it was appropriate at this point in time to have you come back. And since it is the beginning of the year, and hopefully people are pretty much winding down with taxes, to be able to take a step back and to really look at the things that they need to do. So I'll start with, first of all, I always like my guests to just kind of tell a little bit about their backstory. And so with your backstory, it will lead us into how you decided to get into, especially estates planning, estates, trust. Because even to me, I'm like, oh my gosh, and doing research. That's a lot of information you need to know. So let's just start with that, and let's tell our viewers a little bit about who Miss Cora Lewis is. What's your backstory?
My backstory is that I went into law after graduating from Mills College. At the time I graduated, women didn't have many opportunities to basically do professional jobs and go into job training of that sort. So I couldn't type, so I couldn't work as a secretary. So I started out clerking, and then I saw a job opening with Internal Revenue Service based on taking an exam, and I do very well exams. So I scored high on the list and went to work there, and was introduced to law and also to taxes, etc. And after being there for 4 years, it wasn't a place I wanted to be anymore. So I went to law school, Bolt Hall, and spent the 3 years there and came out and worked for corporations for about 14 years. Then I became a financial planner. And then I went back into law because law is much more attractive to me. And I've always been interested in estate planning because it comes out of the English tradition, and I'm an English literature major, of passing property on since the Crusades. And it's also a very pragmatic kind of approach. It's working with people. I didn't want to work in a corporate setting. I wanted to solve problems for people and to make sure people had information, educate them. So estate planning suited those qualifications that I required in order to enjoy my work. And so I've been doing that since. You get to know people, and you get to be very helpful and educate, and problem solving is in the mix of that. So
Yeah.
that's why I did what I did.
Okay, all right. Well, as I said, when you're really trying to unravel the information around wills, and not just wills, there's living wills, there's the trust, revocable versus irrevocable trust, which we'll get into. What's a durable power of attorney? Those kinds of things. And so, I'll just say, well, first of all, let's just start with what a trust is, because a lot of people, I think, and I should say people that I've spoken to, when we talk about a trust, they think that they have it all wrapped up. So I'm just going to punt to the expert and say, okay, well, let's first of all identify so people are really clear on what a trust is, and then to talk about what's the difference between a revocable versus an irrevocable trust. And although it sounds like it should be pretty straightforward, let's
Mhm,
just clear it
mhm.
up for our viewers. So what say you?
Okay, all right. So a revocable trust is the basic document in estate planning for people with a house or significant property. So the trust is an arrangement codified or put forth in a document that states that you are going to put property into your trust. And when you place property in that trust, you're going to designate someone to manage that property. And there's a person who will benefit from that management and that ownership of the property. And that is the beneficiary. So you have three parties. You have the grantor, the person who puts the property in the trust. You have the person who is the trustee that will manage the property. And you have the person who is the beneficiary who will benefit from the property in that management process. And that can be those usually are the same three people. Um, that's you. You are managing your property, but now the trust owns it, and the trust it will be administered in accordance with that ownership, and that ownership is recognized by banks and other institutions that has a valid entity to do that. You have to record your deed in the name of the trust. If you don't put property into the trust by title, the trust doesn't govern it. So trust is like a basket of instructions, and you put your assets that you want to be governed by those instructions into that basket. And as long as they're in that basket, property titled or property disposed of in that basket, then the terms of the trust apply to it. If it's not, then the trust doesn't apply to it. So trusts are generally entered into to avoid probate. That's the most common reason when you have a house, particularly in California. Other states don't have expensive housing, but California has expensive housing, and the probate costs lots of money because it's based on fees based on the value of the house. And houses in Oakland are averaging $1 million, so that can be pretty expensive and reduce the estate that you leave for your loved ones.
Hmm. So, and that brings up a question. Two, actually, you said two things that wanted me to question. You talked about having a beneficiary. Now, usually when you have a beneficiary, would you recommend that there be more than one beneficiary? And the reason for that, what if someone can no longer fulfill that duty or those duties? Or what if the person becomes ill or has to take care of someone ill that's sick? So is it recommended that you actually have more than at least one beneficiary?
Okay, so let me clarify. The beneficiary is the person who benefits from the trust. So the trustee is the person who manages the trust. And generally, if you're managing it and something happens to you, you want to have a successor trustee to manage it for you.
Okay, yes.
Okay. So you should have a successor trustee, sometimes two. I know as time passes, people get older, they want to change the trustee because suddenly some of those people have died. Their sisters and brothers have died. I had a client recently, and that's happened. So she's now naming their children to
Hmm.
take care of her affairs because she's only got one brother surviving, and so she's naming somebody to help him out, and then she's naming other people to serve certain roles in that process. I generally recommend a minimum estate plan of a trust, durable power of attorney for healthcare, advanced healthcare directive, power of attorney for property. Because power of attorneys are only effective when you're alive. The trust is effective when you're alive and when you die, but
Hmm.
you do need those documents when you're alive too, and you make sure the trust is properly funded.
Right. Okay.
Mhm.
So revocable versus irrevocable. Once someone sets up a revocable or irrevocable trust, there's nothing that can be done about that. Is that the case?
Well, times are changing, but generally, trust once it's deemed irrevocable, there are reasons
Okay.
for it that are very strategic, and the reasons have to do with wanting to set it up so that you avoid a specific kind of taxation, or you're looking for asset protection. A revocable trust does not provide you asset protection. It just simply manages the property in terms of the instructions you have in place. But a irrevocable trust has tax benefits, which are not as important now because we have this huge uh, asset exemption in place where you don't have to pay taxes on the property in your estate. But they may be coming back since now there's a lot of debt out there, and the government will be looking for money, and those exemptions will likely come down.
Mm.
So the irrevocable trust is a trust that is in place. You can't change it, but there's a process called decanting the trust where you can make corrections to it. But generally, you don't want to mess with it because you have taken it out of your estate and made it a separate person in essence that pays
Mhm.
taxes. And therefore, if you disrupt that, then there are a lot of consequences that are negative with respect to taxes. And you also want the asset protection that you got by having that trust in place.
Oh, okay. So that's irrevocable that
That's
you
an irrevocable trust, right?
that you do
Exactly.
not want to touch. Okay.
Uh-huh.
So then there is something called a special needs trust. Now, explain. I'm thinking that it may have something to do with maybe someone who has a child that maybe has a disability or something. But would you explain to the viewers what a special needs trust is?
Yes, a special needs trust is a trust that's designed to allow a disabled person to qualify for Medicaid and also to qualify for other welfare type benefits. There are income limits and asset limits in order to qualify. So it's used in two particular kinds of cases. It's used when a person has a catastrophic injury, gets a large settlement, then the attorneys usually bring in a special needs attorney to create a trust, and that money is placed in the trust to satisfy the needs of the person who's injured, but still allow them to get these other benefits because there's some things you can only get through Medi-Cal and through the welfare system. There's just some kinds of care that's not available even to people with more money. So this allows them to do that, to draw on this money uh, for their needs, living needs, and then when they die, all that money that's left over will go to Medi-Cal in order to reimburse them. Then there's the private special needs trust. The private special
Oh.
needs trust is someone who is a relative or a friend establishes a trust for that person's benefit, and that trust has very special terms whereby only certain kinds of things can be paid for. For instance, they're getting welfare, so they're getting food stamps, etc. Those funds cannot be used for those things because they're already getting them. But you can do something like buy them a computer, you can take them on vacation, you can buy them a car. So it allows them to have some cash that their relatives have put aside for them to have some extra benefits that they would not normally have. And so those are the two primary special needs trusts. Then there's something called a pool trust, which is a general fund that you can put your money into and draw on if you're a special needs person, draw on, and that money is used for your benefit too. So there are a number of ways in order to assist a person who has a disability by providing money, but also not affecting their benefits. And that's very important because those benefits can't be obtained anywhere else.
Okay. Well, the government always finds a way to get their money, huh? Or get
That's right.
I'm like, really? So when we talk about a testamentary trust, um, what's the difference? And that's why I said you guys, and I know I see your comments, and I will actually share them with Miss Cora in just a moment. But let's get through the whole trust, things here. So, what's a testamentary trust?
So a testamentary trust is a trust that's inside of a will. Generally, when you do an estate plan, you have a will, but in some cases, people have their will as their primary estate planning tool and don't use don't use the trust. And some people will do that because they I had one client who had no living relatives that were close to her. So she didn't mind having to pay money in probate. She was leaving money to her friends and to NACP, etc. And so she wasn't concerned about saving those fees. So she just did a special did a will and the other documents. And so a will a will is something that people use basically because they don't want to do that. But you can have a trust inside of a will, and that's a testamentary trust. Usually,
Okay.
if a parent uses it as a primary estate planning tool, they
Mm-hmm.
put the trust inside. That trust becomes effective on their death when the will is probate. So that trust will then generally is for children. So that money is inside the trust and it'll be administered for children who are minors in the event of their death.
Yeah. Oh,
Mhm.
okay. And I
Yeah.
think that that was one of the things. So I hope one of the viewers asked, "What about the things that you want to leave our grandkids? Should siblings be the trustee over each other kids if they are dependable?"
Hmm. Okay, so you have to look at the character, the things that a trustee will be doing. A trustee will
Okay.
be doing the management of the assets. They usually don't do the actual raising of the children. That's done through a guardianship designation. So when you designate a trustee, you want to make sure that person is honest because they're going to be overseeing the money, that they are loyal, that they're going to make sure the trust works, that they're willing and able to do it because it's a lot of work. You are actually managing the assets, paying out distributions in accordance with the terms, making sure you're correct, working with lawyers, the banks, etc. So you have to be willing to do it too. And then there are the other kinds of things, qualities that you want that relate to the actual management of it. You want that person to be loyal, fulfill the terms. But when you talk about children and raising children, that's a separate category of document called a guardianship. Guardianships are usually designated in a separate document called a guardian designation. California provides for that. And it's also usually in the will. Will is a normal place to designate the guardian of minor children. So the guardian attributes are ones that you have to think about so that they're consistent with what your values are, that these people are responsible. So you have to look at the personal attributes of people raising your child and make a decision based on those kinds of things as opposed to whether or not they are likely to treat the property well. You want your children treated well. You want consistency. I know I was sitting in probate court one day because I was picking up some documents and I sat next to a man and a child, and they were there for the guardianship court because the child's mother had died and designated him as the guardian. And so we talked a little bit about that process. She had advance notice she was dying, so she had time to choose that guardian.
Mm-hmm.
And they seemed to get along very well, and she seemed happy. So that was a situation where the person had put some thought into who would be the proper person. And this was somebody the child knew already, proper
Okay.
person to raise that child.
Okay.
Hmm.
All right. We have one other question. I'm going to put it up here. What does that mean? This goes back to when you talked about the trust being properly funded, and the viewer wants to know, what did you mean by the trust being properly funded?
Okay, so if you want the trust terms to apply to an asset, it has to be properly funded. So that means with respect to a house or real estate, the deed must be in the name of the trust. So it would say Cora Lewis, trustee of the Cora Lewis Revocable Trust. Okay, so I hold that asset in my capacity as trustee of my trust, and so it's in the trust. Now, it used to be that mortgage companies said, "Oh, we don't trust, so you have to take it out, put it in your name, and then you're supposed to put it back in." And a lot of people just never put it back in. So banks now have changed their process to recognize that. If you have a bank account that you want in the trust, you've got to put it in the title of the trust. So the trust becomes the beneficiary of that bank account on death. So you just have to title the assets in the name of the trust that's placing the asset in the trust, however is appropriate for that particular asset. If it's outside the trust, and what I normally do is put a list of assets attached to the trust,
Mm-hmm.
because if you do that, you can at least go to court, and you don't go to probate. You go to court and say, "This is was her intent. It's shown here in the documents, and so we want you to court to give an order to place it in the trust. So it's a shortcut that's allowed in those cases. But if you don't say anything about it, then
Right.
you have to take it through probate if it's above the probate amount of $166,250 value, and you want to avoid that. Right?
I say, rail those numbers off, Miss Cora. Okay. So y'all, you can see she's really trying to help you and save you a lot of money. And for those of you who really and truly are, I see a lot of you are here in California. I'm not certain where some of the rest of you are located, but this is just great information. So look, Miss Cora is here to answer your questions. We're going to take a really quick break. We're going to come back, and I just really want to dig into, and Miss Carolyn, I'm not quite certain if you were asking a question about POA or directive, but we're going to come back and we're going to talk about a durable power of attorney. But you guys, you're tuned in to You Didn't Get the Memo. And I always say, if you don't take anything away from our show, then you didn't get the memo. So we got some great information for you we want to share with you. So guys, don't go anywhere. We'll be right back.
With Julia's autism, loud sounds can be too much.
But she still loves to make music.
Yeah.
Play band.
Early screening for autism can make a lifetime of difference. Find out more at screenforautism.org.
Have you ever seen somebody treated unfairly because of the color of their skin?
Do you guys know what it means to have white privilege?
What is racism and what do you think about it?
Because of you, I feel not alone in this world. And you let me know that it only takes one person to make you feel wanted.
All right, I want to thank you guys so much for hanging in here with us. We are talking with estate and trust attorney, Miss Cora Lewis, and we're just talking about the trusts and the wills and all the other things that I say, oh my, it causes your head to spin. But this is information that, guys, it's time for us to quit playing around and get serious about taking care of business. And so, Miss Cora, before we went to break, one of the things that I just asked, if we can just come back and talking about, what this durable power of attorney, what's the significance of having one? What is that all about? So can you unravel that for us, please?
Sure. Part of estate planning is not only planning for your assets, but it's planning for your potential disability. So when you have it in a trust, the trust has provisions about what happens when you become disabled and can't manage your affairs. There may be a term in there that says, okay, that's determined by a physician, for instance. So once you get a statement about that, then the trustee who you've designated as succeeding you steps up and takes over. And they use that certificate basically to show authority when they're dealing with businesses that you are now the successor trustee and this is the reason. So it's part of the process. So when you talk about durable power attorneys, you're talking about one for healthcare, you're talking about one for financial affairs. There are two of them, and they're quite different. One is the financial affair one, where that person now takes over, they can take over your bank accounts. It's an exhaustive list. They take over your insurance, they take over your all of your assets, and they take over your IRAs and that kind of thing in terms of management of those. Now, in this process, the trustee, durable power attorney agent, they're fiduciaries, so they have an obligation of trust. They are supposed to manage your assets as you would and use them for your benefit and not for their own. Of course, that can be misused if nobody's there to monitor it, and it is misused. So you have to sort of try to build accountability in the process, if you can, as an attorney, to prevent that from happening. So the durable power attorney for financial affairs is basically, there's a statutory power attorney that includes everything that's delineated in the code passed by the legislature. So by using that shortcut, you say, okay, I want to check real estate. So everything related to real estate is set forth in the code, and that governs your authority. Then you have the one that attorneys may draft where it has all of them listed for your convenience, and you get to see what it is that you're allowed to do. Now, what makes this durable is the fact that generally power of attorneys terminate when you no longer have the capacity to act. So they no longer are effective. But a durable power of attorney says if that person is now unable to act because they're incapacitated, then this power of attorney does not terminate. Instead, becomes effective with respect to the successor power attorney person that you've designated, and that person steps in, and they would have a doctor's statement attached to the document when they're dealing with banks or whatever to show that that is the case. And that's accepted practice in California, so you won't likely get any pushback on that part of it. There's the dual power of attorney, the dual power of attorney for healthcare. Healthcare is another situation where consent terminates when you can't make a decision unless you have this in place. If you don't have it in place, then a person goes to court and get a conservatorship, and they take over your management of that. But then you have to go to court, and you have to wait, and that kind of thing. So this allows you to pre-plan and say, I want this person to make my healthcare decisions. If I can't, of course, by the time you have talked to them, let them know what you want. But this person can make healthcare decisions for you again when you're incapacitated. And those are part of the terms of the documents that are created in the estate planning process.
And that's an awful lot for people who are watching. You guys, it's more to it than just I'm the one that takes care of her. I'm the one that takes her to the doctor's office. Because then what ends up happening when you don't have these things in place, I would imagine that you have family members, and I can just speak from what I know, that all of a sudden they show up. You hadn't seen them, that long lost niece or nephew, and all of a sudden they're thinking that you've got money and assets, and they come in and they're like fighting you on that. And I think that that's why it would be important to have those kinds of things in place, especially you aren't able to speak for yourself. And usually in those cases, someone making a decision about whether to take you off life support or not, or I can just imagine trying to figure all of those things out. Do you want to be a donor? Do you want to donate, organs? And it's really crazy. And as much as people say they don't want to talk about it, the thing is, Miss Cora, and you weigh in on this, but I would think it's better to have something in place, and if you need to make some changes, that you can do that rather than not having anything. The world, at least here in California, I mean, between California, Texas, Florida, with these mass shootings and people you just never know. You could just be walking down the street and something could happen. So I think that it would stand to reason that you would want to put these particular things in place.
That is correct, and the documents are free. Okay, California has a standard form document. You pull it out, and that form you complete it. You think about it. You talk to whoever you're designating to be that agent for you, under that power of attorney, and make sure that they understand your wishes. There's a website called caringinfo.org, and you can go there and also get the forms for various states. They have all the states on there, and they have information about where do you keep it, what kind of conversations you have. They have all kinds of aids in order to help you make that go through that process. Another thing too is that with respect to the power of attorney, you have to know where to put it, right? So if you have a medical power of attorney, you got to make sure it gets to the doctors. You got to take it to the hospital, right? The people you deal with, so they know about it in advance, and then that takes care of it. And generally, you don't want to have, several people making the decision about your health care, because you don't want them fighting about what it is that you want done. So you choose somebody that is reliable and will go forward with what you want, and you do it. Some people don't. Some people want everything thrown at them when they're dying. Okay, and some people say, "Well, I just want to be comfortable. I don't want all this extraordinary measures." So that's something you make a decision about. And there, on the caringinformation.org, there is a booklet called, what is it called? End of Life Decisions. Okay.
Oh, okay.
End of life decisions, caring info. It's the National Hospice and Palliative Care Organization. I'm in the process of reading it for myself so that I can revisit my decisions in case.
Right.
But yeah, it's a big book and it talks about all the different kinds of, care and stuff that you can opt for. And it's good to be conversant with that when you're making your decision.
Right. So for someone, let's just say, who went on the California website and they found these documents, they filled them out, and they come to you and say, I'd like for you to look over this and make sure that I pretty much have everything in place. Is that something that you would do?
Oh, sure. Yeah.
Okay.
Uh-huh. The documents, as a actually, there's a register for the Advanced Healthcare Directive. Now, I don't know anybody that's used it, and I don't know how widely it's used. But there is a website that you can register it so that so that it's placed in a secure place.
Okay.
Of course, you have to remember to change it if you need to change it, but it is there, and you can just Google it and find it and place it there if you don't have anyone to leave it with now.
Yeah. Oh, that's good. Now I didn't know
Hmm.
that.
Hmm.
I know some of the major healthcare systems like a Kaiser, Sutter,
Yeah,
they have, a
yeah,
place.
you can register it with hospitals too in
Yeah.
their databases. Uh-huh.
So that's really good to know. Okay, so moving on. I still want to come back to talking about the fiduciary responsibility you mentioned early on. And my
Hmm.
question is, what's the recourse? Just because, people change,
Hmm.
situations change, things change. Um, and if you've made someone a fiduciary, and all of a sudden you notice that this person isn't acting in the most scrupulous way,
Right.
um, how do you, especially, the fact that maybe someone's not have the capacity at this point to be able to say, hey, I need to make a change, but a family member sees that the person who's supposed to be acting responsibly is kind of, at least I've heard this, they're running through money, they're spending and doing things. If you know that you've got someone who's more or less just kind of total care at home, but you went out and bought them a $5,000 Apple computer.
Hmm.
How does one deal with and get around removing that person who has that fiduciary responsibility?
Okay, so first of all, when a person dies and they have a trust, or generally you're entitled to get the copy of the trust if you are a potential, if you are a person who's a beneficiary. So you know what they're supposed to be doing, right? And you have 120 days to contest it in the event you think there's undue influence. So the courts are very open to, and there's a lot of options to bring a suit in order to ask, for instance, for an accounting if they didn't provide you a copy of the trust. Okay. So the court sees these lawsuits all the time because when money is involved and these kinds of things go on, there's all kinds of emotions, envy, whatever, that make people want to be malicious, if even if they are correct or incorrect. So you can always take it to the courts if you have a grievance about someone's management of the trust. Unfortunately, I mean, first of all, you give them notice that you think something is wrong. You give them a chance to comply with your request. But if they don't, then that tends to indicate that they are probably doing something shady, or at least not cooperating with the beneficiary. So
Right.
you want to call them to account, and that's
Right.
the way you do it. Hmm.
Oh, okay. Okay. And you know, when I think about, I'm thinking about my own personal experience now when my father passed away, and my sister, who was the executor of, my eldest sister. And one of the things is, you always got one in the family. So,
Hmm.
demanding, I want to see a copy of that will, and you change that will. And so, you know, what are your thoughts on when a will has been produced? do all the family members, are they entitled to a copy of that will, even if they've not been involved in the care of the loved one, even if they hadn't spent a nickel, to even send them, a lollipop? How does one deal with that? Does the
Well, a will is required to be a will is required. The original of the will is required to be deposited with the court. So you that's why you know about the movie star's estate, because in California you have to deposit the will at the court and people can go and look at it.
Mhm.
So and that's not everybody does it because $50 to make the deposit. And some people just skip it if there's no issue. But that is something that's required. And also, if there's a trust and you're a beneficiary, the trustee is required to give you notice about it. Again, people can be stealth about it, but if you find out that there is one, you can go to court and ask the court to have them produce it.
Oh, okay, okay. Now that's something I know. Well, like you said, $50.
Yeah, right. You say, oh, no problem. So why do I put it at the court? Just keep.
Right. But it's amazing what's important and what's really not important, but they'll sweat you about it.
Right.
But they don't want to spend the money. Okay. So let's talk about you know, probate and why people, the living, should be concerned about it. And I really want to hone on that because given what's happened with the pandemic, given how people, I don't know. I guess a lot of people think they're just going to live forever and never think about it can't happen to me. So, when we come back, when I come back around to this and I keep hitting on this, talking about um you know why the living should really and truly be concerned, and especially, Miss Cora, when you've got blended families, you've got children from different marriages. And more often than not, I've heard of and seen in some cases that just doesn't seem to mix because whoever the deceased is, their family members, of course, feels like that they should be in charge. And so, can you just shed a little light on what takes precedence over blended families and when a loved one passes away?
Yeah, you have mess even if the family's not blended. Because people are jockeying for position and reliving sibling rivalries and all kinds of things surface in that process. But blended families are particularly a sensitive topic and one that should be addressed through estate planning because what happens is, okay, so you have different kinds of blended families. Okay, you have a couple and let's say the husband has a child and they're both raising the child. That's one form of blended family. You have the Brady Bunch where you have each person having several children that they're raising together. And then you have the ones where there's an adult child that a spouse has. And then they have smaller children that are joint children. So the blended family comes in all kinds of components and raises all kinds of issues. If the husband, say for instance, has a adult child, marries a younger woman, then he wants to leave his property to his adult children, but he also wants to provide for his younger children. So you have to plan accordingly in terms of what the desire is about it. But it should be addressed as part of the process of estate planning between the couple. In terms of what they want to see has legitimate and has equitable, and it's their property. They get to do what they want to do with it, but there are different kinds of trusts where you can do that. For instance, you can say the wife can live in the house as long as she is alive, and if she leaves, then the house will be sold and the money split. You can say, okay, on the first death, this property will go here to if the husband dies, it'll go to his children, a half of it, and the other half will be for the benefit of the wife. So you have to negotiate that with the parties have to negotiate that, and you help them out in negotiating what their options are. So it is something that should be addressed because it can get pretty ugly and after the death of the first person because things are unclear.
Yeah.
And a lot of times the wife ends up with everything. I know I used to get, when I first started practicing, I get calls all the time from children saying, well, my father, my mother passed first, my father got the house, he remarried, and so we're getting nothing. Yeah, that's right. You're getting nothing.
Mm-hmm.
It also depends on how you're holding title to the property. When you have a house that's separate property, and then you get married, and now you have a mortgage on it, and now it's community property because community income is now paying the mortgage too. So you have a mixed asset. So you have to sort that out. You may have to do some premarital. You may have to do some marital planning in terms of, um, you know, providing for that in a separate document. It's more strategic, and it's more complex in terms of making it happen, so that people have a sense of fairness about it.
Yeah, it's interesting how a lot of adult children, when their parents have remarried, feel like that they're entitled
Mm-hmm.
to, to everything that the father and the stepmom or the
Mm-hmm.
new wife, or in this case, her new husband. And that I'm just still always baffled by how it is that adult children feel like that everything should be coming to them, even if, well, you were married to my mom, and so even though that was the second wife, and then you got the grown kids. So when you say problem solver, puzzle worker, then that's why we need people like you who can unravel all of this and really and truly make sense of it, because I could just see this just being just, people going down a big old rabbit hole and it not getting
Yeah.
any better from that point. So thank you for talking about that. When we come back, we got a couple of other things that I want us to be able to cover off on. And guys, if you have questions, be sure and place them in the comment section. You are watching You Didn't Get the Memo show. I'm your host, Gloria Bailey Ray, and my awesome guest, Miss Cora Lewis. And we will be right back. So, guys, don't go anywhere. Thank you.
Thank you for watching the You Didn't Get the Memo show with your inspirational host, Gloria Bailey Ray. It's your contributions that make this happen. To become a sponsor, send an email to youdidn'tgetthememo@gmail. That's the letter U, didn't get the memo. If you're not in a space to be a sponsor, but you like what you hear, we simply ask that you support what you like by making a contribution to the show. There are 3 ways to make an online donation. Visit paypal.me/Gloria Bailey Ray or Cash App or Venmo, Gloria Bailey Ray. Give what you can. Your support is appreciated.
All right. I want to thank you guys for hanging in here. And as you can see, we strive to bring you, the viewer, relevant, fact-based information to help you be informed and to make informed decisions. And today, this is what it's all about in talking with the state and trust attorney, Miss Cora Lewis. Miss Lewis, before we went to a break, I said I had a question, that for me, uh, and maybe others who have it. Let's talk a little bit about, should the executor be concerned about paying off any remaining debt when someone passes on? Is that the executor's responsibility?
Yes. Okay, so you have the executor is actually the person who does probate, and the court requires the debts be paid.
Hmm.
So in the case of a trust, you have a trustee, and it's a different process because you're not in court, and if you don't give notice to the creditor, then maybe the assets may be gone before the creditor can get to you. Okay, so There are rules about that, but if they're not observed, it may be that the creditor might be left out in the cold. Now, if there's a mortgage, of course, the mortgage is going to be paid. But if there are other debts like credit card debts, the creditor may not get paid. And if the assets are already paid out, it's a little bit difficult for them to recover those.
Wow. So they have no recourse if you owe credit card debt. They not able to come after anything? So basically, it's just a write off for them. It's a bad debt write off.
Yeah, because probably by the time they find out, the assets have been distributed, right, by
Hmm.
the trustee, and the trustee didn't know about it, right? So you can't say, oh, they didn't pay. You don't come after the trustee because it's your job to check if you owed money. There is a process, but generally the person is not held accountable if they don't know about it. I mean, the only way you know about it is by going through the records of that person. And if you've done your due diligence and then find it, like a personal loan or something,
Right.
by if that person has done their due diligence and followed the process, you don't expect them to be able to sort of post a notice like they do in probate. You know, probate they post a notice, right?
Right.
And that's a possibility, but it's not standard, so it may not be seen if you put it in the newspaper
Hmm.
because it's not in that standard probate format. So generally, no, the creditor writes it off unless it's huge. The smaller credit card debts just get written off.
Okay. Okay. So when someone passes away and they have left a trust, they have a will, and whose responsibility is it to file a final tax return? I've asked that, and I've met people who say, I never filed a final tax return, for my parent or,
Mhm.
for my spouse. So is that a common practice or an uncommon practice?
Well, I think it depends on the situation. You're supposed to, as a trustee, file the tax returns. Generally, there is when someone dies, you're supposed to get an EIN number, right? Employee ID number. Uh, and if there's property in the trust, you're supposed to do that because if the property is sold, the trust now owns it. So the trust has to pay taxes on it, and that's a higher tax rate. So technically, that's supposed to happen. Uh, but if somebody's doing it on their own and don't have legal counsel, and IRS doesn't catch up with them, then it falls where it falls. But generally, one of the things you do, because you're collecting assets, you're collecting bank accounts, and those banks want to see a EIN number, employee ID number from IRS that shows that they can send you information about what they paid out. So it's done in the cases that I've seen. I don't know of any. I haven't had any cases where people didn't do that because normally the administration of the trust tends to take a period of time, and if there's assets and you're trying to collect those assets, you've got to show up with an EIN number. In fact, you have to show with the certification of trust that shows who is now the trustee based on the terms of the trust, that the person is now deceased, that here's the tax ID number, and you collect the bank account. So that's what usually happens when there's that kind of account where you
Mhm.
have to show a tax ID number. But if you don't have to show it, or if your estate is small or for whatever reason you don't need it,
Right.
then people probably don't do it, what they're supposed to.
So supposed to,
Right.
will do,
You
can
know, you know how that works.
do. Right. Okay.
Path of
So
least resistance.
exactly, exactly.
uh, uh,
So when there are minor children that are left behind, is there a different type of executor that is responsible for these minor children as opposed to, because you talked about the different types of trust, but
mhm.
do you need to have a separate executor for dealing with just minor children, not any with disabilities, just minor children, five,
Mhm.
6, 8, 10 years of age, anyone under
Yes.
18? Okay.
Well, yeah, you need a guardian. Okay, so there's two types of guardian: guardian of estate and guardian of the person. So those are two different guardians. I did a guardianship. I did a trust for someone and guardian designations. So in the will, usually that's where it's normally designated. It says I nominate such and such as the guardian of my child or children, and this is my second choice, and you put that person's name in. And then we also had a separate designation of guardian of the estate because the parents weren't together. They had a child, and they were never married, and they had split custody. So he made his friends the guardian of the person and estate. Um, but he made in the will just the guardian of the person because there was no estate assets that were going to be in the will because the will was called a pour-over will. A pour-over will simply anything you forgot to put in the trust, you probate it, and then and the trust says, and the will says, all the assets will go to the trust, and they'll name the trust. So those assets that are probated, if they have to be, they're put into the trust over here. So there's a separate nomination of guardian form that you prepare, and then you also put that into the will itself if you have a pour-over will. So it depends on how your estate plan is structured. But I do both of them in order to make sure that it shows up in a couple of places.
Okay. So what about you live in California, but you have property in other states and you pass? What are the consequences for not having a will or a trust to deal with, the property, and especially when it's out of state? So,
Yeah.
I hear people all the time, oh, I own a home in South Carolina and I own a home in Texas or Georgia, but my legal residence is here in California. How does that work?
Okay, so if you have nothing, you have to probate in each state. So you have to go to Texas to probate that property in Texas. You have to
Wow.
go to wherever else it is. Okay. If you have a trust and that property was properly placed in the trust can just go and collect the property. It says, I'm the trustee. Here's my paperwork. The property has been put into the trust already if you properly funded the trust. Because when you fund the trust, you change the deed on that property to say the trust is the owner. So you own it already as the trust. The trust owns it. You're the acting for the trust, so you get to sell it or whatever you're going to do with it, right? But if you haven't done all those things, you have to go to each place and probate it. I had a trust that I did, and they never got around to hiring an attorney, and that they were going to do it themselves, an attorney in that particular place, Arkansas. So the property was never placed in the trust, and so the trustee now is probating it in that with a probate attorney in that particular city and area. It's complicated because it has to be also be parsed between a brother and a sister. But anyway, yeah, you complicate your life by virtue of having to go and do those probates separately. It's more expensive to do it that way, and so it's better for you to have your plan complete by virtue of titling those properties into your trust, and then
Mm,
it'll be an easy process.
okay. Yeah. Can you imagine? You got to go to a whole nother state to probate in
Hmm.
court that property. Talk- Miss Court, can I say that's a nightmare?
Yeah, it is.
It
Yeah.
just becomes a nightmare. And so I
Hmm.
really hope people who, whether it's a vacation home or it's your semi-retirement home, that this is information that you need to know in order to avoid all of this. Oh my gosh, it's to me, it's a lot of stress. That would be a lot of stress, in my opinion. So, you guys, you're hearing it, you're getting it straight from, you know, the horse's mouth, so to speak. So, Miss Corey is giving you some information. So, what advice, would you give to people, Miss Cora, who's watching the show today? And they're trying to figure out what's the first step. How do I even start with this? Now, you've given them some really great nuggets about just the fact that you could simply go to a website and pull down the documents. So
Hmm.
where should they start if they have not done anything? They don't have any kind of healthcare directives. They don't have a will. They don't have a trust, but they know they working and they making money and they own a house and they got some kids and all this other stuff. Where do they start? How do you advise people or suggest to people where they should
Yeah.
start
Yeah.
this
Well,
process?
first of all, they have to decide if they care enough, right? To do anything about it. Some people don't care, right? So, but if you care, then your first thing is to list your assets, and say, okay, what do I have, and um, is it worthwhile for me to do this planning? Who are the people in my life that I care about? Do I want to make things easy for them by having my information in orderly manner, by virtue of having a will or a trust, whatever is appropriate. Sometimes, if trust, usually people get them if depending on the asset size. The asset size is small, they own a little lot and it's less than 50,000, they can get by with a summary probate. So you have to look at what you have and then organize it accordingly. Some things don't go into trust. For instance, a bank account can have a beneficiary designation, or so that you can say, I want this account to go to this person, and put that on the bank account, and they just pick up their property when you die.
Right.
So you look at it and decide how you want it to go, and based on complexity or size or whatever, then you decide you get some professional advice and put things in order. And it is a process. It's not something easily done, uh, depending on the scope of your assets. But even if you don't have assets, if you have a child that you need to name a guardian for, um, you educate yourself and identify what the issues are that are important to you. Your children are important to you to have some guardian. You need to talk to people about it, who might be the person you're going to appoint, and you have to think about what you need. And I know we all have busy lives, but you can make it part of it and do it partially, and definitely do the do the advanced healthcare directive. You can address that issue. You have a form for a power of attorney. You may have trouble deciding who you trust enough to give those things to. And maybe you have nobody. So what if you have nobody? Some people don't have anybody. Or some people say, I'll have my best friend do it. Well, maybe the best friend doesn't want to do it. There's something called a professional fiduciary that, it's relatively new. This person is a professional trustee, professional um, healthcare provider kind of thing. So you can find people who are friends or people who are professionals who do that. There's a California fiduciary organization that has the fiduciaries who serve in these roles, and their rates vary depending on what roles they are playing. But that's a fairly new organization, and so fiduciaries, for instance, may do accounting for you. They may do. They may be the ones making healthcare decisions for you. I don't know what the charge is for that specific service, but yeah, it behooves you to find somebody. Otherwise, people die, and there's nobody knows who to contact, right?
Right.
So you have to make connections in order to make it work for you. But again, if you don't care, then that's fine too, right? Yours is yours. You can do with what you want.
Right. We have two quick questions before
Mhm.
I ask you what it is that you want people to take away from today's show. And the first one was, will you need a lawyer in each state? Basically, she says, I would imagine you will need a lawyer in each state. And the second one was, what about property that's abroad, outside of the U.S.? How should you handle that? And I'm assuming, viewer, that you're talking about if you're doing a trust and you're asking how do you handle property outside of the US. Hit me back a comment if that's not what you're asking. So,
Okay, so with respect to property in other states,
mhm,
yes, you do need an attorney because a California attorney cannot practice law in another state. So probate involves going to court, and if you go to court, you generally have to be qualified in that state, licensed in that state. In some cases, you can go to court and you can register, but that's federal court. You can just register yourself with the new court. But most state courts don't do that. They're protective of their lawyers, so they don't allow outside lawyers to do work in their courts without becoming a part of the bar there. With respect to outside the country, those laws are particular to that country and govern that. If you don't have a, if you don't, even if you have a trust or whatever, in the process of creating that trust, you maybe never got that property into the trust because that means getting an attorney in that place to make sure it's done properly. So when you're out talking about laws in other countries, like even like Canada, they have their own laws that apply, and so you have to comply with those. And again, an attorney who is not licensed there is limited in terms of what they can do. So I would have to find an attorney for that person, and then work with that attorney outside the United States if I were doing that kind of thing for them. That's the way it works.
Okay. Okay. So thank you for answering that. So our time, it always flies. It's like people always say, "What are you going to talk about for 55 minutes?" And before you know it,
Right.
so you've given us some great information, but I would like to ask, what is it that you want people watching the show today, Ms. Cora, to take away from our conversation?
Well, estate planning is not about documents. It's about who you care about and the property that you care about and taking care of your loved ones. One of the things I suggest people do in order to make things easier is provide a little love note with your estate plan to help soothe the savage beast in the event there's somebody there who is. So you can communicate your values and why you did what you did and what's important to you about the family, and have a love letter to them to help smooth things over because so many things erupt in the process that people are torn apart, and it's good to have be thoughtful about it, even if you don't do the plan itself, but at least leave a thoughtful letter or message that helps to soothe things over.
Yeah, I like that. Leave a love letter, and hopefully, people will be able to embrace what it is that you've said and respect
Mhm.
what you have said. Ms. Cora, I can't thank you enough for again. 3 years is too long, but I always learn something new when we
Right.
talk. And I want to thank you so much for being here with us. You guys, I have been placing Miss Cora's information for you to be able to contact her. And you see her number there on the screen. Be sure and reach out to her if you have questions. I can assure you, this woman is absolutely awesome. And one of the viewers just said that's a good idea to leave a a love letter. And I have to show you this. One of the viewers says, Miss Cora is dope.
Thank you. I do provide a 30-minute free consultation. So if you want to call to
Okay, you guys heard it, a
consultation.
free 30-minute consultation. It doesn't get any better than that, you guys. So let's take advantage. This is really and truly what this show is all about. Miss Cora, don't you go anywhere. I'm going to be right back with you. I want to say to all of you that have tuned in, you had questions, you had comments. I really appreciate it. Again, I want to underscore, you just heard Miss Cora says she does provide a 30-minute free consultation. And you guys, nowadays, there's no such thing as free for so many people. Please honor my guests, and I really hope that you took something away from today's show. I always say, if you didn't take anything away from today's show, then it really and truly is you who did not get the memo. Guys, I'm always grateful to you for being here, for sharing. I'm going to ask that you like, you follow, you share this information. The interview will be up on Facebook and YouTube. Go back and look at it over and over. Share it, you guys. Come on, it's time for us to do something and quit talking about it. As we say in the South, you got to poop or get off the pot. So let's take advantage of the information from my guest today. Guys, um, remember this. The quality of your life is determined by the decisions that you make. Until this time next week, be sure and tune in, tell a friend, like and follow. Be well, be blessed. Peace.